Great stuff. Good morning, all those that are funneling in, um, and welcome to the final quarterly legal update webinar of 2024. We'll give it just a minute or two and let some more people funnel in, and then we'll kick things off.
Almost certainly the last one, probably.
There you go. What are you saying? Do you know something we don't, David?
I just know that things are changing so fast.
That's true. We might have to do well. We could make them monthly or even bi-weekly if we need to. But
Oh
there
my
we go.
Lord, no.
All right, hopefully we've given everyone a minute or two to join us. So I think we'll kind of kick things off because it's not like we have much to cover, but there you go. Good morning all, and yeah, welcome to the what I was just saying, the final Fixflo quarterly legal webinar of the year. We'll be covering, of course, Renters' Rights Bill and everything that's involved in that today, and a few more other bits and pieces, and of course get our classic legal update from David. But as always, I'm in fact joined by the omniscient David Smith. David, good morning. How are you?
I prefer omnipotent over omniscient, but one's even less likely than the other. I'm good,
Uh,
thank you. And
Good.
obviously very like opposite because we obviously planned this totally in advance.
We did.
That today is the first day of the committee stage of the Renters' Rights Bill, and they are already sitting there right now taking evidence. You can watch it on Parliament TV if you're that way inclined. I am not there. I'm so glad to say.
There we go. Less said about that. Less said about that, the better, perhaps. But just before we actually crack on, I wanted to congratulate you on your legal LinkedIn influencer nomination award.
Well, the more you like those posts, the more likely they are to you more likely you are to see more me. There's an incentive not
There
to.
you go. That's all we all need in our lives. So there we go. But does this mean we'll soon see you in holidays in Dubai and posting pictures of your Ferrari? Is this the route that's being gone down?
No, I was looking at this actually because actually one of the things that's interesting about the report is the posts that do really well are the kind of things where people post personal stuff, but I have quite a strict rule of not posting anything
Ah,
too personal. My wife and daughter, for example, have never appeared on my social media, and I don't see that changing. So I'm hampered by only being able to post about property law, which I think is
ah.
really interesting, but apparently not everyone wants to see a non-stop diet on property law in their LinkedIn feed. I can't honestly imagine why.
No, I know I said in jest, but genuinely, I think with everything changing so frequently and things moving so quickly at the moment, it is really amazing to have someone like yourself on all of our timelines. I know I speak for lots of people, so thank you for keeping us so up to date. And I think that's a nice segue into what we're kind of going to be covering today. So, of course, Renters' Rights Bill and everything that goes with that. We'll also cover some other pieces of legislation and other things that have been said by our Labour government in the first 100 days. Kind of a nod to EPC Mission 2030 coming back, and we always knew it wouldn't go away for forever. And also a bit in kind of leasehold and freehold, although we have done another webinar on that, so we won't touch too much on those topics. Before I crack on with things and ask David a myriad of questions, as always, our legal disclaimer. So all content presented in this webinar is intended just for general information purposes and should not be considered as legal advice or guidance, especially what I say, that is. And also, as always, we want these to be as interactive as possible. We've got loads of questions fed to us already, which is brilliant and not surprising with everything going on. But yeah, the question button, hopefully you're familiar now, down in the bottom in the chat button there, or the Q&A button, sorry, do type your question and our brilliant marketing team will feed them through to David and I and as we go through. So I think we'll kick things off. Renters' Rights Bill.
Unsurprisingly.
Unsurprisingly. David, do you want to give us a bit of an introduction about, I don't know, you can't cover everything that's happened in the last few weeks, but a bit of an intro, and then we'll dart off in various specifics as we go through.
Yeah, so the rights bill obviously is most famous for getting rid of Section 21 and fixed term tenancies. Although I think today we're going to talk about some slightly different bits about it, which is nice because I mostly end up talking about the Section 21 stuff. Obviously, the government was very clear it was that they were getting on with this, and so the committee stage starts today, ends on I think the 28th of November. And I'm guessing that it'll probably end up back in the House before Christmas for its third reading, ready to be punched across to the House of Lords from January, which of course is consistent with the overall timeline of getting this at least partly in place from the summer next year. And obviously that compressed timeline is I mean, there's a sense in which this is good in the sense that we've been mucking around with this since 2019, and the reality is it's probably better in some senses just to get on with it and have some degree of certainty. Obviously, as against that, it now means that there's a lot of change happening quite quickly that people had probably not really prepared for in the vain hope that it wouldn't happen. And they're going to have to make some change pretty quickly. And of course, there's always the other challenge that in when change is quite radical, that people have to just emotionally cope with it, not just get their heads around it, but also accept that this is the way it is, and that will lead to dislocation and discombobulation among in the market for a while things resettle. But I'm sort of confident that things will sort themselves out. I mean, the problem here is that I don't think that there will be the same landlords in the market after this is done necessarily letting the same property types, and that, to be fair, is something the Labour government's perfectly okay with. I think what's dangerous about that, and what the government has forgotten about, is that if you don't have the same landlords letting the same property types, that may mean that there are some groups of tenants who are no longer being served.
Who do you mean specifically about that? I know you mentioned students a few times. Is that mainly where you're going to?
I think is one of those groups who in some areas might find that their provision in the PRS drops away. And then certain types of tenant who are less well off. And there's an interesting boundary, of course. You've got tenants who aren't terribly well off, but aren't so unwell off as to be entitled to universal credit. And there are some landlords who target the universal credit market, particularly in areas where the UC payment is quite high as compared to other rents. So they can do very well. There are areas around outer London where that happens, for example. But that often leaves people who aren't entitled to UC out in the cold. So there will be categories of people that are being currently served that may find they're not being terribly well served as the market adjusts. And there has been evidence, quite interesting evidence of specific parts of the country bucking the overall trend, which is gently for landlords to sell, and has been for some time. There are specific parts of the country where landlords are buying in significant numbers. And then also, of course, the nature of landlords is changing. The NRLA's average landlord now owns 4 properties. A couple of years ago, it was 1 and a bit. Well, more than a couple of years ago, but not that many years ago, it was 1 and a bit. So the reality is that there are fewer landlords in the sector owning more property. Now, people say that's a bad thing. I don't know whether it is or it isn't, but that is the government's design.
I think it's certainly a trend. A few years ago, the term accidental landlord was something that was very common, and it does seem those things are moving further and further and away, or less of them. And that kind of 4 property average is an interesting point. I know you mentioned it's all you ever talk about, but the abolishment of Section 21 and periodic tenancies, I think it'd be remiss of us if you couldn't give your default elevator pitch on what's kind of changing there, just to flag to everyone once more, and then we'll kind of go.
So no more Section 21, no more fixed terms. All tenancies become assured periodic, and the only way of recovering possession will be through one of the now nearly 40 grounds for possession under a Section 8 notice. So, so in practice, most landlords will be able to get properties back when they need to, but it will be more complicated to do so, and they will have to be able to justify it. And then there are a whole load of other things there. There's limits about rent bidding. There's obviously significant restrictions on how rent increases happen. Those are kind of, I think, sort of the three. And then the new PRS database, new redress schemes. Those are sort of the big ticket items. And then there's repairs.
Then there is, yes,
Which is where we were going to go today, I think.
Yeah, no, exactly that. I think, as you kind of said, focus on the less figures in bold and the big changes we all know quite well about. So I think the key thing, we got a fair few questions coming in prior to the webinar, was all about decent home standard, as it's something that hasn't applied to the PRS until now. So I guess a bit of background context from you first would be great.
Yeah, so let's start with decent home standard. The decent home standard has existed for a long time, and in fact was recently revised in the social sector. So social landlords are subject to decent home standard. Now, interestingly, private landlords are kind of subject to it as well, because the English Housing Survey, when it surveys property, including when it surveys private sector property, does actually measure them against the decent home standard. So there is a measure of how many properties are non-decent in all the different available sectors. And so that is done by a decent home standard assessment of private rented sector property. So there is an element in which the decent home standard does kind of touch on private sector property at the moment, but not in a very substantial way. And this sort of comes back to one of the problems with the HHSRS. The trouble with the HHSRS is it's a fairly statistically focused and quite complex risk-based analysis. Not all local authorities understand it very well. Even fewer landlords understand it very well. The guidance documents for it are quite lengthy. Amusingly, the landlord guidance, which is supposed to be the easy read version, actually has more pages in it than some of the statutory guidance documents for operating the thing. And so it's all a bit long, and most people don't read it, and they don't get it, and they don't understand it. And because it's risk-based, it's very difficult in respect of any particular property to say whether it's up to standard or not without going and doing a full assessment. Now, there was a logic to this system because it was meant to be quite flexible and allow us to deal with the fact that properties just aren't the same. And the old mechanism that it replaced was quite sort of hidebound. It basically said, well, you have to have this and you have to have that, and this has to be like this. And that meant that there were some hazards that simply didn't fit into those categories and therefore were ignored. And then there were some situations where something was really quite minor, but there was a pretty excessive response to it because it fitted, broadly speaking, within one of the existing categories. The irony of bringing the decent home standard back in is we are sort of turning the clock back to a series of fixed requirements that you have to meet. And the objective of the decent home standard is that you will have to meet a set of fixed requirements that must be or not be the case in your property. Now, at the moment, for social landlords, the decent home standard basically says there must be no Category 1 HHSRS hazards in your property. There's a kind of odd point there that the decent home standard is being promoted as making it easier because you don't have to do an HHSRS assessment. But of course, you can't really say whether or not there are Cat 1 hazards if you don't have to do an HHSRS assessment. And then it also says that that things over specific ages must be in repair, but those ages are quite old. I mean, they're sort of like, walls over 80 years old must not have holes in and things like this. So for many landlords, the decent home standard isn't likely to intersect them a lot because it's quite a low-level standard. And so the idea here is really that you'll have the HHSRS continuing to operate. And the HHSRS, of course, only impacts you once the local authorities inspected your property and said, well, we've done a test and you're not up to the standard. And so we require you to do this, that, or the other thing. And unless it's really serious, you'll be given some time to make some repairs. The decent home standard is different. Decent home standard is added to the HHSRS, so it's going to amend the Housing Act 2004, and there are various regulations that will come in to make it live. And And so in a sense, I don't know the detail of what's in there because the government hasn't had a consultation and passed the regulations. But the idea behind it is that you must meet the decent home standard all the time. And if I turn up at your property and it's not meeting the decent home standard, you are already in default and I will be able to penalize you, regardless of whether I've actually notified you in advance of what you have to do. So it's basically a minimum standard you will have to meet all the time. What will be in it is hard to say. I suspect that the government is probably going to leave the Cat 1 HHSRS hazard in there. So severe HHSRS hazards are likely to find themselves popping up in the decent home standard. And that creates a problem in and of itself because local authority officers don't always operate the HHSRS very well. And frequently they mess around with the figures in questionable ways in order to force things into category 1 hazards because of their own policies and the way that they work internally. Whereas in fact, they might actually be more appropriately lower level hazards. So the danger here is that local authorities are going to find higher level hazards for their own separate reasons, but which will also then intersect the decent home standard.
Interesting.
So there's going to, I suspect there'll be a lot more challenges and debate around the operation of the whole thing. And then there'll be some other menu of things that need to be up to spec. I mean, I should imagine they'll be looking for basic structural soundness, no leaks, and no severe damp issues, those kind of things. So sort of fundamental stuff. As I say, most people shouldn't have a problem with this most of the time, but where it is different and where it's intended to be different is that it's a fixed standard you have to meet all the time. And of course, what we're really targeting here is the relatively small number, but the very serious houses in the dodgy side of the private renter sector that are very, very, very far below standard.
I think, yeah, that's the kind of key takeaway there in framing that is a nice way. It's introducing a minimum standard. You don't have time to resolve these repairs now. They're expected to kind of be there. All these standards of housing are expected to be there all the time. I think so. Yeah, it's a nice way to put it. Is the kind of big red flag. That's the difference.
But I think the key thing that will be important to people is people will need to have some kind of decent home standard checklist.
Yep.
Be checking against the decent home standard at appropriate points, and then making sure that they are addressing those decent home standard matters as priority repairs. It's a sales opportunity there for you, Will.
Yeah, no, I know. I'm trying to resist every fiber of my being right now, but so we'll try and move it on. But there you go. But yeah, no, of course, we can keep a record of all of that for you. And I think there's other ways to do it, but it's just having that documented. So just in case when the local authority comes knocking, in case they do, you're prepared. Ultimately, it's all about keep you safe from those things that can go wrong. I guess just jumping back in slightly there, you kind of mentioned damp and mold, and I think that kind of links nicely to the other key addition or piece of application on repairs in the Renters' Rights Bill, and that's AWAB's law. Again, just a bit of an explainer from you here would be great.
Yeah, so background, this all stems from the untimely death of a young boy called AWAB of Shak, who had respiratory problems anyway, but was living in a social property where the housing association involved basically just weren't repairing damp and mold growth. They suggested, possibly because of some degree of racial prejudice, but I'll leave that as an open question, that it was the lifestyle of the family that were causing it. That was a pretty weak argument. And he ultimately died of respiratory failure due to breathing in mold spores day in, day out, which is not very good for you, in case anyone's in any doubt. The government, which of course was not the current government, the previous government, then introduced something, a provision in the Social Housing Regulation Act, which added a new section 10 big A to the long-suffering Landlord and Tenant Act 1985, which I'm sure most people on this call will be familiar with, because section 11 of the Landlord and Tenant Act 1985 is landlords' core repairing obligations. But it only applied to social landlords, and it's still not actually fully enforced because the government had a consultation because it has to pass regulations. And then before that, just as that consultation finished, somebody called general election. And so everything kind of stopped. So none of this is in force at the current time. What the Labour government has said is, well, they want to apply AWAB's law to the PRS as well. And the Renters' Rights Bill does that because it further amends the amendment to the Landlord and Tenant Act 1985. So Section 10 Big A, instead of just applying to social landlords, will also apply to PRS landlords. And what the government has said is they've made it apply separately so that in principle, they can have different obligation levels for social and private sector landlords. But the way they phrase the explanatory notes leads me to think that they're not really that keen on having different levels for social and private sector landlords, and they probably intend to treat all landlords the same under this. Now, what's interesting about this is that all this actually does is it implies an obligation into a tenancy agreement, just like Section 11 is implied into your tenancy agreement. Or the homes fits for human habitation is implied into your tenancy agreement. So if you don't do it, what it actually means is that the tenant has a right to come after you for compensation. So it's to sue you for money, basically, for not having complied with your obligations. So I'm a bit wary of how real this is, because the reality of this situation is that the vast majority of less well-off tenants in poor quality property simply don't have access to legal advice. If they all did, they'd be suing all these people for disrepair left, right, and centre. And frankly, the courts would order them to improve property, and many of these things would never happen. But they tend not to intersect with legal advice in the courts that often, and often tend to prefer to avoid lawyers. I mean, obviously, lots of people prefer to avoid lawyers. That's not terribly surprising, but you know, I spend a lot of time sitting in the corner of the pub on my own. But there are specific groups who are very keen to avoid interaction with the legal sector, because they perceive them as being, you know, organs of the state, and sometimes they've come from countries where lawyers are not to be trusted, frankly. And so they find it difficult to access legal advice. Anyway, what will AWAB's law contain? It's hard to say, but there was a consultation, quite a detailed consultation, how it would be applied to social rented housing. Now, I anticipate that the government will rerun that consultation at least for private sector housing, but I suspect their starting point is going to be that the standards already laid out in the previous consultation. They may choose to amend them a bit, but I think they'll probably stick broadly with them and apply them across the board. So what you are required to do is, if there is a hazard in your property that fits within the 29 currently 29, potentially in future 21, because the HHSRS has also been reviewed, though we don't know what the current government intends to do about that review. But if there is a hazard in your property that fits within the 29 hazard categories of the HHSRS, that's not an HHSRS assessment, it just fits within the 29 hazard areas and creates a significant risk to an occupier, then, or has the potential to do so, then that requires, that then drops it within the scope of AWAB's law. What you will then be required to do is you will have 2 weeks to carry out an initial investigation. That doesn't necessarily require you to turn up in person. That investigation could be done remotely, and sales opportunity for you again, Will. There is an organization you guys partner with?
Yes. Video triage and things like that.
Video triage. So a video triage essentially will fall within the scope of AWAB's law. I mean, obviously, in some cases it won't be enough, but
no, of course not.
But it will be a start, and it will probably let you meet some of your initial requirements. You have to do this as soon as you are aware of an obligation. So unlike most of the other stuff in the legislation, which requires a tenant to actually report something to you, if you become one, you can't specify the means of reporting for the purposes of AWAB's law. Any reasonable report will do across any platform. But you may also have just become aware as a result of scheduled maintenance or inspections. So currently, if I do an inspection and I see something that's a repair, I'm not actually obliged to do anything about it unless it's reported to me. Probably ought to, but technically the obligation is on the tenant to report. That won't apply for the purposes of AWAB's law. To be fair, it's very few people treat the law that way anyway, and the courts are somewhat cool on people who turn around and say, well, yeah, I saw the leak, but they didn't tell me
I can
about it,
imagine.
so I'm not liable. It's not a,
Yeah.
it's not the most brilliant argument to deploy in court, but it is technically an argument. So if you become aware, you're required to do an initial inspection. The suggested timeline is 2 weeks to produce an investigation, and then produce a written summary of your findings, which need to be given to the tenant. And again, I think one of the interesting things about the kind of stuff that you guys do is those kind of written reports are produced automatically out of your systems. You don't have to produce a written finding if it's an emergency repair, and those are set out within the scope of discussion. I'll come back to that in just a second. If it then causes a significant risk, you have to start repairs within 7 days, whether they're temporary patch repairs, or a full repair, or a temporary fix while you investigate further. And you must complete those within a reasonable time. There's no timescale for completion as long as you get on with it. And the reason for that, of course, is that different types of repair are going to obviously need different types of outcome and will take different types of time. So, it may not be, it's not really practical to set something. If it's an emergency, you have to start within 24 hours. And if there is imminent risk of harm within the 7 days, but it's not an emergency, you are required to decamp the tenant while you at least patch it up and make it better. Emergencies are really serious stuff, gas leaks, loss of water, loss of boilers. Think basically lack of heating or hot water or serious leaks of anything are likely to fall within the emergency category. So, I mean, one of the things that's different about this is obviously loss of boiler is potentially an automatic emergency, which requires you to work within 24 hours. So obviously people will need to be identifying those and acting promptly. And what's also important about this is it's based on the risk to the actual occupier of the property. So although we've used HHSRS categories, the HHSRS is based on risk to notional occupiers. This is based on risk to actual occupiers. So, for example, if you let to a family with a young baby and they don't have heating, that is likely to be a very serious risk to the health and it's January. That is likely to be a very serious risk to the health of the baby. If you're letting to strapping young fellows like yourself, Will, and it's August and their heating's defective for a couple of days, that is unlikely to be an emergency because they're all down the gym all the time anyway, and they can have a shower at the gym and they'll be fine, and they can wear an extra jersey. So it's fact sensitive, but you will need to take that point into account when dealing with this. And then you're required to keep records as well. So all the repairs and stuff you do must be recorded in an appropriate system, so that they're available for inspection at some later date. Again, the problem here will be there will be lots of people who think that AWAB's law should apply to them because it's causing a significant risk to their health, when in fact there isn't one. So the problem is that there are some people who you will have to act promptly for. There are other people who may think that you should be acting promptly, but in fact their risk category is low.
Indeed.
And I had an example yesterday. I was speaking at an event, and some lady told me about a story about her own property where she's got a tenant who is complaining about disrepair and but won't let them in to fix it. But it's mostly things like spiders, which obviously don't fall within the category of things that are a significant risk to your health, because spiders in the UK are not generally poisonous and are not going to kill you. And ironically, the same woman won't let them in to do a gas safety inspection, which does strike me as a more serious risk to her health. But there you are. That's people for you. That people are
Yeah, but
different.
the focus is on the spiders. So there you go. Great, David. That's great. Thank you so much. I get there was one just in fact final kind of piece on renters' rights, and you touched upon it at the very beginning. But the kind of format and way in which rent increases will be allowed to take place. Just a quick explainer on that, and I guess the questions that a couple of people have sent me in context to that is, of course, tenants being able to take it to the first tier tribunal, and then already we hear you a lot in these updates and kind of state about the capacity of the courts, and how will they be able to take this on, and is there kind of any structure in place for that?
Yeah, I mean,
Has it quite been thought through? I guess I'm kind of hinting towards, but yeah, just
thought
rent reviews.
through. Yeah, but probably not enough.
Okay.
I mean, the position is that if you want to do a rent increase, you will have to use a Section 13 notice. That will be the only option. You can't agree a rent increase. There are only two scenarios in which you can reach an agreement. I have served you with a Section 13 notice, and then I agree with you that the rent will be lower than the amount on my notice. I would suggest to many agents that that is the way they will want to go if they can manage it. The second option will be that it's gone to a tribunal determination at the tenant's request, and you then agree a lower number than the tribunal has said the rent should be. I can't really imagine anyone ever wanting to do that because the tribunal's already said you can have the higher rent. So why would you agree less? I suppose unless you want to keep the tenant in the property and they generally say they can't afford it and you believe them.
Mm.
What's interesting about this is that Section 13 applications tribunal are free and always have been. And the tenant and the tribunal already gets a significant percentage of applications that are basically just a largely blank form with a Section 13 notice stuck on the back saying, I contest this, or worse to that effect, and they can have to do all the heavy lifting themselves. They will remain free. There's been quite a significant increase between the 22-23 and 23-24 years in terms of the number of applications. And obviously, I expect that will go up. The reality is lots and lots of tenants don't contest Section 13 notices because they only have a month to do so, and it's very strict. But that's being increased to 2 months, so they got longer to contest it. I think you'll find the notice will be much more explicit about the right to contest. And of course, the reality is not very many people in the PRS use Section 13 notices because they sign a new fixed term tenancy with a higher rent on it or something like that. So although not that many tenants contest Section 13 notices, obviously if you massively increase the number of notices, then fairly obviously tenants will then turn around and contest those notices. And if it's even the same percentage as it is now, you're still going to get a massive increase in tribunal work.
Yeah, because the total volume,
Yeah.
makes complete sense. Makes complete sense. Robert,
sorry. So the next problem is that the tribunal, whether it can deal with the load. Currently, the tribunal claims that it's taking 4 to 6 weeks to deal with stuff.
Okay.
But I know that's not true because I've had a case in the Eastern Tribunal last year for a rent increase on a rent act tenancy that took 6 months. I've got a case in the Southern Tribunal where it's going to take them 6 weeks to even open the post and deal with, because we rang them about it and said, where's our application? They said, well, it's going to take us 6 weeks to organize this and list it for a judge to consider it and give you directions. So I don't think that the tribunal's figures are wholly accurate. I think they're going to get a lot worse. I'm given to understand at the moment there isn't any more money being given to the tribunal to deal with this additional workload, although that remains to be seen. So I don't think every tenant will contest every Section 13, but I think more will, and I think that's going to be a problem.
Yeah.
The side effect of that is it's totally in the tenant's interest as well, because unlike the current system, which says that once the tribunal determines the rent, they backdate the increase to the notice date, and they can go higher than the notice if they think the market rent should be more than is on your notice. Under the new regime, they don't backdate the increase at all. It takes effect from the next rent payment date after the tribunal's determination date. And further, the tribunal can't increase the rent above the notice level. They can only go down. So it's always in the tenant's interests, really, to contest a rent increase, because even if the tribunal was to give the landlord the number on the notice, they're still going to be putting it off by however long it takes the tribunal to deal with it. So this is why I think what agents should be doing is quite a careful tactic of looking for a rent increase, which is probably the upper end of the available band, giving it to the tenant, probably with some evidence as to why it's a good increase, but then saying, but we'll accept this today if that's what you're, if you don't want to contest, if you elect not to contest the notice and agree this, here's a written agreement which you can sign, which increases the rent to some lower number, in the hope that the majority of tenants will rather than contesting it through the tribunal, but end up having to pay the full amount on the notice, will take a deal whereby they'll pay a bit less today to get it done.
Yeah, that makes sense. That makes sense. We've had a question. Can you see them on your side? Coming from Robin. Hopefully, if you pop that up, it'll
See the question. Oh, I can see the questions.
There you go.
During the tribunal period, what happens to the Section 13 rent? Well, it just doesn't increase. There is no rent increase during that period because, as I've already said, the tribunal, the rent increase doesn't happen until the tribunal determination has been completed, and the rent increase date is the date after the tribunal's determination. So either the tenant doesn't go to the tribunal, in which case the rent increases automatically at the end of the notice period, or they do, in which case the rent will increase when the tribunal has dealt with it. So in a sense, there is no rent increase during the period in which you're going to the tribunal.
Interesting. So they've said 6 weeks is their official line, but for a fact that's not quite the case, and we expect delays to perhaps.
Yeah, I don't think they'll be turning these things around in 6 weeks. They might occasionally, but I don't think there'll be many turned around in 6 weeks. And also, each tribunal district is a separate zone. So there's a London tribunal, there's a southern, there's an eastern, and there's a northern, and there's a western, and there's a southwest one, and they're all their own admin place. And in my experience, the London one is incomparably more efficient than all the others, but than all the other ones, and some of the others are shockingly poor.
There we go. We'll move on from that one now.
I think two more things about repairs, actually.
Oh, go on.
One more thing about repairs. So just to go back, one thing that I also wanted to point out is that in the Renters' Rights Bill, there is a new power to apply repairing standards to licenses as well. So licensed property, as in property not let on a tenancy, let on a license. I don't mean licenses as HMO licenses. So one of the potential ways around the rights bill is to use a license, but the AWAB's law stuff is likely to be pulled across to cover licenses, but the real target of that is not the PRS. It's actually social landlords with people on temporary licenses. So people who are homeless are often placed on temporary license agreements, often in accommodation provided to local authorities by the private rented sector. Frequently, that accommodation is shockingly poor and just grossly substandard. The government is basically putting an obligation in there potentially to improve the standard of that property as well. But it probably applies to all licenses. So you can avoid lots of things by using a license, but you won't be able to avoid the repairing obligations, I suspect.
Perfect. No, good to know. That's one of the things you said. There's two more things about repairs.
That was it. Sorry, there's one more thing. The other thing we'll talk about later because there's a legal update section which I've forgotten about. I only have one interesting case that I think is worth talking about.
There we go. We'll come back to that one momentarily. So I think in terms of Labour's first 100 days in government and moving on to that, as I said, so we did and this is focused on letting agent this webinar. We did a brilliant webinar a couple of weeks ago with which was hosted by Nigel Glenn and Cass Zanelli, and it did everything about the Leasehold and Freehold Act becoming law and the debate between commonhold and freehold and all that good stuff. So a quick plug there to kind of go back on the Fixflo page and listen to that webinar, because they did it. It was a brilliant conversation, and they really did it justice about all the eventualities that could happen. And the other kind of key piece is mission EPC C or equivalent by 2030 is very much back on the cards. I guess, David, I know you kind of mentioned when we last spoke, I think you said it just kind of drifted into the distance or wasn't on the agenda anymore, and I'm not surprised that it's back, I guess, is the kind of thing, key
Yeah, I
thing
mean, the
around that.
government's made a formal announcement that they are bringing it back, so that's back. They're going to put, I presume, hold a consultation on all this. I mean, I think what's really interesting about this is that it's only been 100 days, and I was watching the Laura Koonsberg show on Sunday where she was having a go at Wes Streeting, the health secretary. Like, you said you're going to do this, and, why haven't you done it yet? And it's like, Jesus, it's only been 100 days, and a month of that was parliamentary recess for summer holidays. They cut it to a month. And people don't really appreciate, but the way the parliamentary calendar shakes out, the vast majority of parliamentary business gets knocked off in the spring. So there's the period from sort of January through to summer recess is the sort of main meat of the parliamentary calendar. After summer recess, because you've got conferences and then you get into Christmas, things tend to not get done. So the very fact that they're likely to push through the renters' rights bill before Christmas is unusual in parliamentary terms. But when you look at what's happened in the first 100 days, it's a hell of a lot. I mean, they've published the renters' rights bill. They've amended the National Planning Policy Framework, the NPPF. There's been clear announcements and processes started on compulsory purchase, and indeed the Law Commission has been asked to look at CPOs again, about further planning, about another leasehold and freehold reform bill of some description. So there's been a lot of announcements. Obviously, those things have to come to fruition, but these things take time. And I think, and what was really, I was actually at a conference last Thursday where the housing minister was speaking. I thought there were two things that I thought were really interesting. The first is he was asked, because one of the things that's interesting about Matthew Pennycook is he's actually quite a good minister, as these things go. And I hold no particular candle for him, although he is, I would have to honestly say, quite a pleasant guy. Having met him once or twice, perfectly is quite a nice. I mean, I've met less pleasant people in ministerial roles. Let's put it that
There
way.
you go. Stop there. There you go.
Yeah, I'm not going to name names, but some of them are still MPs. So I've met less pleasant people in ministerial roles. He's a pretty nice guy, but he's also really all over his brief. And so one of the things he was asked is, well, it's all very well you saying all these things and doing this stuff, but you're quite good at your job. What if you're not doing it in 6 months' time? We're back to square one,
It's a
aren't we?
fair challenge.
Well, yeah, and given the laughable turnover in housing
A
minister,
revolving door. There you
yeah,
go.
it's a fair point. But he actually said, well, yeah, fair enough. And he did actually say, well, I obviously serve at the Prime Minister's pleasure, and I might be fired, so I can't control that bit. But he then said, but I did say when I took this role that I didn't think it would work unless I was in it for a considerable period. So he certainly anticipates being in the role for several years, which I think is quite notable. And then the other thing that he was very clear about is that the government sees housing reform as a multi-year project. And when you look at the kind of things they're talking about doing, it would have to be. I mean, talk about compulsory purchase. So the government said it's going to get rid of hope value and things like that. But it's not just doing that. It's going back to the Law Commission. There'll have to be primary legislation. This is, this won't happen until 2026. So I think the other thing I would say is, if you don't like what you've seen in the first 100 days, you ain't seen nothing yet. This is, I mean, I don't mean that all of this will fall on the PRS, because it won't. But the government is absolutely clear that it intends a substantive, across the board reform of every element of housing and house building in the United Kingdom, and indeed land use generally. within the United Kingdom, and they are pretty adamant that they will not let local authorities, developers, vested interests stand in their way in doing that. And you might disagree with some or even all of what they are doing, but the one thing you can't fault is their determination to do it. And after a number of years of extremely off again, on again, maybe we will, maybe we won't. Oh, we might. Our MPs don't like that. Let's not do it. Oh, we've not really got a majority. Oh, there's lots of other things we're interested in. The dedication is interesting. I mean, the only thing that I wonder is the housing minister and Angela Rayner are committed to this, but there are a few other ministers in the cabinet, and they may not all have the same dedication. And indeed, I imagine the Chancellor of the Exchequer may not be entirely committed to funding every element of what they would like to do, at least not in the short term. So I don't know how they will survive the normal slings and arrows of the political process within their own cabinet, as opposed to the rest of us. But
makes sense.
a lot's happened, but people need to anticipate that this is a starting point.
Definitely. I think you surmised it nicely there, of saying that it's almost rare that you feel this will be pushed through before Christmas and in the Lords in January. And in times gone by, it might have waited until that January to springtime when lots gets done. So I guess watch that space as well as what's coming up in the close future, the not too distant future as well is coming. Perfect. Thank you for that one. Anything else you feel worth mentioning in the first 100 days? Or should we move on to your one key legal update that we've got?
That was my main.
That was your key point. No.
About it, yeah.
Perfect. So on to the final section, and then we'll open up for a few questions and answers. So do ping them through if you have anything on David's agenda. And he's asked me not to mention the influencer piece again. So every questions on everything but that. But there we go. So there is a chance the Renters' Rights Bill will come into effect before Christmas. Question from Leah. Not quite the case, but David, do you just want to make sure in terms of time frame? Yeah, go for it.
No, it won't come into effect before Christmas. That's not possible. It's got to go through Parliament, through the Commons, and it will not finish its committee stage till late November. It is possible it will get third reading, but it's still got to hit the House of Lords, and the House of Lords will want to debate it. They may well be time constricted, but they will want to debate it. And the House of Lords really does very little after about the second week of December, apart from host drinks parties, frankly. So no, I don't anticipate the House of Lords getting their teeth into this before January. So I think it will have finished its. I think the bill will have finished its House of Commons transition before Christmas. I do not think it will have finished the whole parliamentary transition before Christmas.
In terms of amendments, they can happen at almost every point, can't they? And then can come back in. Do you expect anything of note to come out in the amendments? I know it's hard to predict, but
well, there haven't been any amendments published today. I mean, at the end of the day, the only amendments, the matter of government amendments. There will no doubt be lots of other amendments from other parties. I don't anticipate any of those going anywhere, because the composition of a bills committee obviously reflects the composition of the House, and look who controls the House pretty thoroughly. So I'm sure various amendments will turn up and disappear again. I don't anticipate significant amendments from the government at the moment. I mean, they indicated a willingness to look at the rent and advance issue. There's a real level of confusion about rent and advance at the moment. I don't think it's possible under the bill. Tenant groups clearly think it is. MHCLG officials seem to be suggesting that you can't have rent in advance, in the sense that you can't have a longer payment period, but you could ask the tenant to make multiple payments. I don't see how that's possible, but they say it is.
That work. Okay.
But the housing minister also indicated it was an area he was receptive to further discussion about. So I'm not sure what it is that they intend to, where they intend to sit on rent in advance. I mean, they basically said that they wouldn't allow large upfront rental payments to block tenant access to property. and that seems to be what rent in advance is. So I don't understand how they can, with one breath, say you can have multiple payments, but then say, but we're not going to allow that to happen. And it's like, well, it doesn't make any sense.
Yeah, it'd be interesting. I guess it kind of brings it because you automatically putting a time frame on a periodic tenancy, aren't you? If you're, I don't know, paying a year in advance or two or
Well,
whatever it
and
might be.
that's what they're trying to. They're trying to avoid long payment periods because they do seem to be of the view that tenants' notice, while being 2 months, must accord with the must expire at the end of the period of the tenancy.
Mhm.
So what they're trying to avoid you doing is gerrymandering that by saying, well, then you have to pay the rent 6 months in advance, and that's the rental period. So you can only give notice every 6 months.
Okay.
So they're trying to avoid that scenario. But then I think the way they've written the legislation, I don't think allows rent in advance as a side effect. But they don't seem to think that I'm right about that. But in the reality is it'll end up in the court eventually, one way or another, I should think.
Yeah. Yeah. What's that space indeed? So on our final part, a legal update for us, a case of note that you wanted us
Yeah,
to
there was only
review.
one that I thought was opposite to what we're talking about, which is a gas safety case. And I should be very clear that this is not um, an appellate decision. So it's a county court decision, but it's a circuit judge, and so it's binding on every district judge in London at least, and is likely to be followed elsewhere. And it relates to validity of Section 21 notices, which are still there, still exist for the moment. um, uh, where a gas safety certificate was not signed with an ink signature or a real signature, and someone I think in this case just hadn't signed it at all. There was no signature box, so it had been sent by email.
Mhm.
And there is a period for British Gas, for example, I don't think they are now, but were sending emailed reports about gas safeties that didn't have any form of signature on at all. And the statutory requirement is to have a signature. The court seemed to say that the right type of signature was a wet ink signature. I don't think that could be right. I think a type signature will do, but
Mhm.
you do have to have a signature. And I would really advise landlords and agents to look closely at the gas safety certificates they're getting through. A lot of them do not comply with the regulations, and the Court of Appeal was pretty clear in Carroll and Ransfield that they would not accept gas safety certificates that didn't meet the requirements of the gas safety regulations. The regulations do specify what must be in a certificate, and they are frequently not completed properly. So it's really important. I mean, obviously this will go away a little bit because currently having a valid gas safety certificate is not a requirement for possession under the new regime.
Mhm.
But presumably you'll want to preserve your Section 21s as long as you reasonably can. So people do need um, to think about that.
Yeah, for sure. Sure. Um, and on that note, we've got a few questions about assured agricultural occupancy in the chat. I'm not sure.
Ooh.
There you go. Get your teeth stuck into that one.
Um,
That come up on your side,
I
hopefully,
mean,
bud.
yeah, the short answer is no, it doesn't. But what it does have is a mechanism where you could serve a not dissimilar notice and then seek possession on appropriate grounds under Section 8. So it has a mechanism that is effectively the same, but not precisely the same. So what Barry's referring to is that at the moment agricultural workers get fully assured tenancies. You can serve a
Mhm.
Form 9 and give them an AST. Obviously there won't be any ASTs under the new regime, so no, it won't work that way, but you will be able to serve notice, and then there will be a ground for possession that links to that, which will have a
Okay.
similar effect.
So, Barry, there you go. And we missed one earlier from Anna, kind of back to our point about rent reviews and the rent increase process. So can the tenant challenge rent within the first 6 months of term at the first tier tribunal?
Yes, they can. There is already power, but there's always been powers to do this. I should hasten to add. It's only the first 6 months of the initial term. There's always been powers to do this in Section 22 of the Housing Act 88. Those powers are being reenacted, and certainly the government's intention is to make those powers more front and centre. so they're more obvious. And the reason they're doing it, in part, I suspect, is to deal with the negative effects of rent overbidding. Because one of the side effects of saying, well, you can't have rent bidding above a set price is that people will simply put very, very high prices on properties, and someone might then pay it. But what you should bear in mind is if you put a completely laughable price on your rental property and someone pays it, they might in fact then go and challenge that price inside the first 6 months and have the rent reduced.
Interesting. I don't suppose there are any cases of that. Well, there might be in the future. Could be one we're doing in a legal update. So there you go. Hopefully, can you see the questions from your side, David, or do you want me to? Do you want me to
No,
read them out to you?
I'll answer them happily.
Go for
So
it.
someone's asking me on GSCs, it's very confidential not to be present at the time engineer visits. How do we overcome the need for a signature from the tenant? Well, you overcome that need because it's not a need. There is no requirement in the regulations for tenants to countersign GSCs. People just like to do it in order to prove the tenant was presented with a copy, but it's not a requirement of the regulations.
There you go.
And then I'm being asked, if a tenancy becomes periodic under renters' rights, how would we do a deed of guarantee? Can this be open-ended? We understood that having this open-ended would potentially be unfair. Well, yeah, I know people were saying that, but I don't think it's unfair to have an open-ended deed of guarantee as long as you write it sufficiently carefully. So yes, you can still do a deed of guarantee that is open-ended in my view.
Listen carefully. Brilliant.
I mean, I should caveat that with you'll need to write it with some care, in that there is case law that suggests that rent increases beyond the amount previously agreed would invalidate a deed of guarantee. So you would have to write it in such a way as to make clear that rent increases didn't change the scope of the deed.
Good stuff. So that's brilliant. Well, thank you. I think on the next slide, everyone can come and there you go. Follow you. Don't follow me. Follow David on LinkedIn. There's a lot more brilliant content, as promised. Pictures of Ferraris and holidays in Dubai coming soon. But no, in all seriousness,
that's on your feed, Will. Sorry.
In all seriousness, like I said, it's been great. So thank you. And with things constantly moving and constantly changing, I think we all need to make sure we're on top of things. And it's a very easy way by following yourself to do just that. On that, there we go. Thank you everyone for joining us. David, thank you very much, and I'll see you soon.
Thank you.